My name is Denise Evans, qualifying broker at Butler Evans Real Estate, Inc., and this video is about letters of intent in commercial leases and commercial purchase and sale contracts. A little bit about me. I'm an active commercial real estate broker and consultant. Call me for buyer or seller brokerage, referral, or co-brokerage opportunities. I am a retired litigation attorney who specialized in real estate and banking defensive litigation, a former clinical professor of real estate at the University of Alabama Culverhouse College of Business, and a nationally published author from McGraw-Hill, Sphinx Legal, and Kaplan Dearborn. Well, what is an LOI? LOI, letter of intent. In commercial real estate purchase and sales and in commercial lease negotiations, the LOI is a non-binding agreement about key contract terms of primary importance to the parties. If it is non-binding, why do it? Many of the finer points of a contract or lease are negotiated with attorney involvement. There is no point paying lawyers if the parties cannot reach an agreement about the big picture items. That is the purpose of the LOI. What is usually included in a sale purchase LOI? Well, the sales price, of course. Earnest money. The time for the inspection period. Will it be 30 days? Will it be 180 days? Every deal is different. Important seller deliverables. What does the buyer want the seller to give the buyer at a minimum so the buyer can do its due diligence? Financing and other contingencies. Time period to close. After the due diligence is over, how much time is there to close the deal? If it is going to be a sale leaseback, the seller will sell the property to the buyer and then lease it back from the buyer, which is very common with medical office space, for example. Important lease terms. You can't enter into a purchase contract and then hope that the lease agreement is going to be favorable to the buyer. If it is a seller-financed sale, important note and mortgage terms such as the interest rate, the term, the maturity, important default terms. What is usually in a lease LOI? The exact space rented. Parking spaces, how many free parking spaces, how many paid parking spaces, how much will the paid parking spaces cost? A non-competition clause. The landlord will not rent to any competitors in the same project. The lease term and renewal options. Will the renewals be at a specified rate, such as a certain percentage over the prior year's rent, or will it be negotiated at that time? Security, a security deposit, a letter of credit from a bank, personal guarantees. What sort of security will the landlord need? The monthly fixed rent, and often that will be a certain amount per square foot, and the LOI will specify whether that's rentable or leasable square feet, and escalations. Additional charges such as CAM, common area maintenance, and operating expenses, and any caps on increases each year. The tenant improvement allowance, how much will the landlord pay to assist with the tenant's build out of the space to tenants' needs, if anything. Concessions, free rent, building signage. A move clause. Landlord might insist on the ability to move the tenant if, for example, a contiguous tenant needs more space. So the landlord will want to move this tenant somewhere else in the building or in the project. The tenant might say, no, I want the move clause. I want no move clause. These are items of negotiation. And if they're deal breakers, they need to be in the letter of intent before everybody starts paying lawyers. Well, I hope you found that useful. If you have any questions or need clarification, or if you're interested in another topic, please contact me via email, denise@butlerevansrealestate.com, or you can call me at 205-310-3799. I'm in the Central Time Zone.